Good morning. Before we begin, I just want to check. I know that we have Joe Woolman and some folks here for Mount Clair Junction. O'Donnell Street, we have somebody here for O'Donnell Street? Okay. Sale of property, Linden Avenue. Anybody here for that? Comptroller's office, yeah? Okay. Okay, great. And 6901 Reisterstown. 6901 Reisterstown. Oh, that's fun. Okay, we're gonna start. We're gonna take these bills in the order of these routine bills. We're waiting on an amendment from the Department of Legislative Reference on 1421 Ridgely Street, and the sponsor of that bill has a time constraint this morning, so we are going to hear that bill as soon as we have that amendment in hand so that we're able to vote that bill today. We're going to do these routine bills, and then we will go on to the bills on minor variances and crematorium. Who do we have here for minor variances? Anybody here for the bill hearing on minor variances? Okay. And anybody here for the bill hearing on crematoriums? Nobody. Fun. Okay. Good morning. I'm Ryan Dorsey. I'm the chair of the Land Use and Transportation Committee. We have 7 bills in front of us today. We have here with us members of the committee. We have to my far right, Councilman Parker. To his left, Councilman Gray. To my far left, Councilwoman Felicia Porter. Good morning, Mr. Chair. To my immediate left, Councilman Zach Blanchard. To my immediate right, we have our wonderful staff. Tony Leva, good morning. How are you doing?
Good morning, sir. How are you?
Good. We have representatives here from the mayor's office and a range of city agencies, the comptroller's office, and we have some members of the public and applicants for these routine bills that we have here today. We will start today with 2405 Linden Avenue. Sale of property, 2405 Linden Avenue. Let's start with that. This bill was introduced by the council president at the request of the Office of the Comptroller, Department of Real Estate. We have Jay Hardy here. Just 1 second here before we begin. Okay, Jay, do you want to tell us about this bill while we're here for it, just briefly?
Thank you, Mr. Chair. Good morning. My name is Jay Hardy from the Office of Comptroller Bill Henry, and the Department of Real Estate is responding to a request for a report on the sales ordinance regarding 2405 Linden Avenue. In October 2022, the St. Francis Neighborhood Center submitted an initial inquiry for the use of Block 3463A, Lot 8A. And the request is intended to facilitate the creation of a driveway/parking pad for the delivery and drop-off of students. This transaction is just going to involve a land swap, and during the review of the property, it was discovered that when the city constructed the new entrance to German Park, the sideway was inadvertently built on a portion of St. Francis Neighborhood Center. And so the Department of Real Estate is requesting a favorable bill report. Thank you.
Thank you. Any questions for the bill proponent here? Good morning, Councilman Bullock. How are you doing? I'm doing well. Great, thank you. Any questions from the committee for the Comptroller's office? Okay, great. We will hear from the other agencies. Law Department.
Mr. Chair, I don't believe that we were referred.
Oh, okay. Yes, you don't get these sale of property bills, right? Finance?
Good morning, Mr. Chair. Gabriel Stewart-Sikowitz for the Finance Department. We do not oppose this legislation and are here to respond to any questions.
Great. Planning?
The Department of Planning has no objection to the proposed sale and recommends approval.
Great. Rec and Parks?
Good morning, Mr. Chair. Isaiah Griffith, Mayor's Office of Government Relations. Rec and Parks is favorable on this bill.
Thank you. Department of Real Estate obviously is favorable. They are the proponent of the bill. BDC.
Good morning, Mr. Chair, members of the committee. Tom Welly on behalf of BDC. We stand by our favorable report.
Great, thank you. And any questions for any of these agencies from any of the members of the committee? Do we have anybody here from the public to testify on this bill? Okay, great. Do we have any online testimony on this bill? Anybody online who wishes to testify on the sale of property 2405 Linden Avenue, please raise your hand in the WebEx. Okay, seeing none, on behalf of the applicant here, I'll make a motion that we vote this bill favorable. All in favor, say aye. Aye. Opposed, say nay. Abstentions, say I abstain. Great, none. This bill passes favorably by the committee and will be reported as such to the full council at its next meeting. Rezoning, 4188.5 O'Donnell Street and block 6543A, lot 001B. This is Council Bill 250127. I feel like I read the title of that last bill, but not the number. In case anybody's following along here and I was negligent in this duty, the bill we just voted was 250104. 250127, 4188.5 O'Donnell Street. This bill is introduced by Councilmember Parker on behalf of or at the request of the applicant, DJBL Crescent LLC. Councilman Parker, you want to tell us about this bill real quick?
Thank you, Mr. Chair. Thank you to my colleagues. I think the most helpful
For these,
thing,
just for the routine bills today, I'm just going to have everybody just from here when it comes otherwise to policy bills where I think there's going to be more.
I appreciate it.
We'll
Thank you, Mr. Chair. Just flipping through the packet, the most helpful way to describe this is to see it on a map. So if you feel like looking at code map and you're curious about it, it makes it really, really clear why this bill is necessary. The overall property here is most recently used as a scrap metal yard. It's a large property, roughly between O'Donnell Street, Haven Street, and the south boundary is O'Donnell Street, and then it's surrounded by railroad tracks on the east and the west, and it's just south of the Crown Cork and Seal Industrial Park. It has been mostly cleared now and is being prepared for residential development and other kinds of development. And it's a really critical piece of undeveloped land in the area. And this parcel is an industrial zoned former railroad right-of-way that cuts a third of the way in an arc through the middle of the C2 larger property. It's an I2, I think, zoned property, little sliver right-of-way along the western edge and then jutting up into the middle of the property. And it makes the property really difficult to develop. And so from my perspective, it's clearly a mistake that this little piece was left off of the broader zoning. And so this is creating conformity for the entire lot, for the entire parcel there, and allows for responsible development.
But I love scrap yards.
The scrapyard, unfortunately, is past. We have to look to the future, Mr. Chairman.
I missed my opportunity. Okay, any questions for the sponsor of the bill? Do you love scrap yards too?
I would say indifferent,
Okay.
Mr. Chair.
Councilman Blanchard.
For the bill sponsor, so these will be, the plan is to build single-family attached, so row homes.
That was so this is just resolving the underlying zoning so that everything is C2. I mean, once it's all C2, I mean, there's all kinds of things that could be done within that. We were shown an initial design that was a restoring of the street grid and row homes, single family or not, I don't recall, but row home style structures similar to what has been developed nearby in Greektown, just to the east of it. But once the zoning is there, I mean, the property owner can put out any kind of appropriate development plan, and we'll gladly work with them in the community to help advance it.
Yeah. I'm just so thrilled. This is not really relevant here. I'm so thrilled to see the demand for people to build row homes across the city, and to see these projects that are like new build row home developments that are really working very well. So glad to see more of this possibly happening. Thank you, Mr. Chair.
Absolutely.
Okay, great, thank you. We have bill reports. Law Department?
Thank you, Mr. Chair. Michelle Toth on behalf of the Law Department. We approve for form and legal sufficiency.
Thank you. DHCD?
Thank you, Mr. Chair. Jason Wright representing DHCD. We stand behind our favorable bill report.
Great, thank you. DOT?
Luciano Diaz for DOT. We have no recommendation on this bill.
Thank you. Planning?
The planning, Caitlin Audette with Department of Planning. The Planning Commission adopted the findings and recommends the bill favorably, and also concurs with Councilman Parker that this was a mistake.
Great, thank you. BMZA?
Justin Williams, interim executive director of the BMZA, no objection.
Great. Justin, is this one of the reports that we got very
It is, I apologize
belatedly?
for the tardiness of the report. I'm
Okay.
doing three jobs.
We want to make sure we get them in time for the committee staff to include them in the packets in the future. We need the BMZA planning and DOT reports, and we want to make sure that a priority is made to have those reports in hand and included in our packet. Okay, any questions for any of these agencies from any of the members of the committee? Is there anybody from the public here to testify on this bill? Great. Hit the button on the right. There you go.
Okay. Good morning. Brooke Hutchins with the law firm Rosenberg Martin Greenberg. I'm here on behalf of the applicant, and just here to answer any questions. Councilmember Parker did a great job explaining the background of this bill, but if you have any other questions, I'm here.
Any questions for the applicant here? Okay. We need to find facts for this bill. Sorry, 1 second here. Thank you, we'll be okay.
I'd be happy to walk through the findings of facts.
I want to reference the Planning Commission report because they generally have the finding of facts in the report. In order to establish a change or mistake standard, they talk about population change. There's been population of 400 people in the adjacent Brewer Hills community to the west, even though there hasn't really been any change to the infrastructure to support that kind of growth and to continue allowing that kind of growth on this site. The area will be served by future red line. And so there's other pending change, I guess. The parcels are unique in that they are a former railroad right-of-way. There are several other notes in the Planning Commission report here. Suffice to say, the committee members can review that in writing themselves, and that I would put the Planning Commission's findings of facts forward as our finding of fact. All in favor of adopting the Planning Commission's finding of facts, say aye. Aye. All opposed, say nay. Abstain? Shout, do a little dance. Okay, the finding of facts are adopted. We have no amendments for this bill. Councilman Parker, would you like to move the bill?
Thank you, Mr. Chair. I would move approval of this bill.
Great. All in favor of approving this bill, say aye. Aye. Opposed, say nay. Abstain, do whatever you want. Okay, we will report this bill favorable to the full city council at our next meeting. Council Bill 250081, zoning conditional use conversion of a single-family dwelling to 3 dwelling units in the R7 zoning district, 6901 Reisterstown Road. Do we have anybody here on behalf of this bill? The sponsor did let me know that he was ill and unable to make it this morning. I also know that there was a snafu in a previous communication about this bill, and it was the applicant, the sponsor of this bill is not here with us today because he's ill. And whenever somebody has gone to the trouble to do public advertising at a cost and at a significant time commitment, I want to make sure that those members of the public engaging in our process here have not wasted their time and money. And so I feel compelled to move forward with this, particularly having personally been in touch with this applicant in a way that have not others generally for such routine bills, although I am also at a loss as to why the applicant is also not here. So I'm going to hear the bill anyway. Ordinarily, I would not. It is for a very routine rezoning or conditional use in the R7 zoning district. I know in this case, the owner of the property was misled to believe that the multiple units that already existed in the building were rightly permitted to exist, and so they bought the property under false pretense and are now stuck with it, and it's the kind of thing that is essentially allowed anyway. So that's what I can tell you about this bill. We will hear from, any questions for me, since I'm apparently presenting this bill today? Okay, great. Law Department.
Thank you, Mr. Chair. The Law Department approves the bill for form and legal sufficiency.
Great. BMZA.
Good morning, Mr. Chair. Justin Williams, Interim Director of the BMZA. I apologize again for the tardiness of the bill report. We offered no objection, recognizing it's the council's role to resolve the quasi-judicial facts that need to be found here. And we also noted in the bill report that the Housing Options and Opportunity Act would ameliorate the need for this legislation in the future.
Good, thank you. DOT.
Thank you, Mr. Chair. We have no recommendation on this bill.
DHCD?
Thank you, Mr. Chair. Jason Wright, representing DHCD. We stand behind our favorable bill report.
Great, thank you. Planning Commission?
The Planning Commission Caitlin Audette with the Department of Planning. The Planning Commission reviewed the proposal and recommended the adoption of the findings of fact and the equity analysis and recommended approval.
Great, thank you. Any questions for any of these agencies?
Mr. Chair, I have a question for Ms. Audette.
Yes, Blanchard.
Can you just talk me through the equity analysis for this proposal?
Sure, similar to what was said previously, the proposed conversion advances equitable housing opportunities by creating 3 new dwellings within an existing residential structure, increasing the housing supply. This incremental infill development provides additional rental opportunities in the Falstaff neighborhood, which would support a range of household needs, but while maintaining the community character. The project has received full support from the Falstaff Improvement Association, with the contingent that each unit be provided with a trash receptacle that meets the requirements. It's also consistent with the comprehensive plan, which designates the site as a residential higher density, which aligns the project with equitable growth goals.
Thank you.
Anything else? Okay, the Planning Commission has findings of facts in their report. I'll propose that we adopt the finding of fact from the Planning Commission report. Councilman Parker.
Sorry, I'm reading the staff report now. I'm not sure in this finding of facts. It's in the finding of facts or not, so I didn't want to rush into it. The staff report lists a lot size of 4,360. Is that right? I was curious, so I pulled it up on SStat, and it showed a lot size of 3,200.
So the lot contains approximately 4,300 square feet, which meets the minimum lot area requirement, 3,300 square feet for 3 dwelling units. Site isn't,
Right, I haven't personally gone and measured it. I just, it's a big lot size, and so I wanted to check and see what SStat said about the property while we were talking about it.
usually we catch that kind of thing, so I'm assuming this is accurate. I did not staff this, but I can quickly see what is going on with that.
Sure. I just want to make sure we didn't have any facts that weren't in order. It also lists it's supposed to be 3 units, 2 2-bedroom, and 1 1-bedroom, right? And so for it to be a full unit, each of them would have to have its own bathroom. So there has to be so we're talking like a 5-bedroom, 3-bath situation, right? Is the description given? I know we don't have the sponsor here, so maybe this isn't. Again, SStat lists it as, and I'm sure there's an improved basement, but and SStat's numbers are never always to be believed. So, but it shows 1,500 square feet above grade living area, 3 bedrooms, 2 full bath. So I don't know. Again, just because it's an SStat doesn't mean it's accurate.
In any case, the standard for per dwelling is,
Yeah, it meets the standards
yeah,
within the code.
it meets the standard without
And
variance,
I would
even if it
just
is
say-
only 3,300.
Yeah, I would say SStat is often not quite accurate when it gets to those kinds of details. So I would assume that what is in the staff report is correct.
That somehow there's a difference of 1,110 feet between SStat records and the staff report.
That would not shock me.
Okay.
But just to be sure, the tables, the bulk and yard standards for minimum lot requirement for this zoning category is only 750 square feet per dwelling unit. And so even if it is the lesser of these numbers, it has adequate ability to meet that standard for 3 units without requirement of any sort of variance or anything.
Yeah, I thought 750 per dwelling unit, so we only need to be at 2,250.
Correct.
Oh, sorry, the staff report said it needed to be at 3,300 for 3 dwelling units, so that was also.
I think that this report predates.
Predates that change.
Yes.
Thank you, Mr. Chair.
Yeah.
Some of that didn't sound right. Great, cool. Thank you much.
Okay, so only modestly outdated findings of facts here, but I think we've also established that there has been a change in the standard, and so we can take that into consideration as we consider the findings of facts here, which I will put forth for a vote. All in favor of adopting the finding of facts, say aye. Aye. Opposed, say nay. Abstain. Okay, great. We have findings of facts. We will vote on the bill. All in favor of approving this bill, say aye. Aye. Opposed, say nay. Abstain. Okay, great. Okay, we have two more bills here of the routine nature. We have the amendment here for the Ridgely Street bill, so we will hear that one first. 250017, zoning, conditional use, live entertainment, 1421 Ridgely Street. Members, you are having an amendment distributed to you that was just expeditiously put together by the Department of Legislative Reference. I want to note that anytime an agency is saying an amendment is needed, certainly we want to have that agency go directly to the Department of Legislative Reference in order to ask them to put the thing forth, to draft it, especially when we're on a time crunch like this. We just got the report, I think, 2 days ago. So, Councilwoman Porter, you want to tell us about this bill?
Thank you so much. So this is a conditional use for live entertainment in the Pigtown area. And so this would allow this applicant, Checker Spot Brewery, located at 1421 Ridgely Street, to host live entertainment on its premises. The hours would be, the hours for live entertainment would be Monday through Thursday, 3 p.m. to 9 p.m., Friday and Saturday from 12 to 10, and Sunday from 12 to 8. This applicant has gone through an extensive community engagement process for over a year, obtaining letters from the Community Association and support from my office. And so I would appreciate if colleagues would support the bill. Thank you.
Great, thank you. Any questions for the sponsor of the bill? Okay, agency reports. Law Department?
Thank you, Mr. Chair. The Law Department approves for form and legal sufficiency as long as the required amendments are made.
Great, thank you. On the subject of required amendments, committee members, the Law Department noted one amendment that pertained to off-street parking, that because this bill's introduction predates the doing away with the off-street parking requirements, that is no longer needed. And so in asking the Department of Legislative Reference to very quickly put together an amendment for us, I just considered this a moot point, and there is no amendment pertaining to that, which the Law Department noted. Thankfully, it was up to us to decide even if one was necessary. But there is another one that is just very essentially technical, because it's essentially an amendment to the title of the bill, citing the a certain authority that was referenced in the bill but not in the title. So we do have that one amendment. Department of Finance?
We weren't referred to this bill, but we have no objection.
Okay, my little sheet here says defer to planning. BMCA?
I don't think we've prepared a report in this one, but no objection.
No objection. Planning Commission?
Caitlin Audette with the Planning Department. The Planning Commission reviewed the request and adopted findings and equity analysis outlined in the staff report and recommended approval.
Thank you. DOT?
Thank you, Mr. Chair. We have no recommendation on this bill.
Health?
The Department of Health has no position on this bill.
Great, thank you. Do we actually have a report from liquor licenses? It's not required, but it's listed here. Okay. Do we have DHCD? Oh, yeah, you were referred the bill. Sorry, I missed that.
Thank you, Mr. Chair. Once again, Jason Wright, representing DHCD. We stand behind our favorable bill report.
Great, thank you. Any questions for any of these agencies from anybody on the committee? Is there anybody here from the public to testify on this bill? Okay. We will take a vote on the amendment?
Yep.
Yeah.
So I'll move the amendment.
Great. All in favor of approving amendment number 1 from the Law Department, actually it says Dorsey, say aye.
Aye.
Aye. All opposed, say nay. Abstain? Okay, we have an amendment. Oh, we need to do finding of facts also. We have findings of facts in the Planning Commission report. I put them forth as the finding of fact necessary to be able to pass this bill. All in favor of adopting the Planning Commission's findings of fact, say aye.
Aye.
Aye. Opposed, say nay. Abstain? Great. And Councilman Porter, would you like to move the bill favorable with amendment?
Yes, I'd like to move the bill favorable with amendment.
Great. All in favor of approving this bill favorable with amendment, say aye.
Aye.
Aye. Opposed, say nay. Abstain? Great. The bill will be reported favorable with amendment to the full council at the next meeting. We have one more routine bill here, 250101, repeal of ordinances 86711, ooh, that's an old one, and 92147, planned unit development, Mount Clair Junction. Nobody has rethought this site since 1992, it seems.
We're doing a lot of work over there.
Here we are. Good. It's a good time. Tell us about Mount Clair Junction.
Yes, so this is a repeal of ordinance 86-711 and 92-147. Carlisle Next LLC wishes to repeal these respective ordinances to develop certain properties in the area. I will also add that they've also gone through an extensive community engagement process from my office and received letters of support from the community association. And it is of our assumption that the outdated PUD will facilitate beneficial redevelopment for the area to commit it for ongoing housing development for that particular area.
Anybody on the committee have any questions for the bill sponsor? Great. Agency reports. Law Department.
Good morning, Mr. Chair. Desiree Lucky on behalf of the Law Department. We approve this bill for form and legal sufficiency.
Thank you. DOT.
Thank you, Mr. Chair. We stand by our favorable bill report.
Thank you. Finance.
We do not oppose, but when we want to note that the proposed change would allow future projects to potentially add housing on areas currently restricted for commercial purposes and could promote additional economic growth in the area. By adding residents, they will be able to boost area retail.
I love it. And probably better support the businesses. BMZA.
Good morning, Justin Williams, BMZA. We stand by our report, support the legislation.
Thank you. Planning.
Keelan Audette with the Planning Department. The Planning Commission reviewed the proposal and adopted the findings and equity analysis and recommended approval.
Great. Thank you. Any questions from anybody on the committee for any of the agencies here? Do we have anybody from the public to testify on this? Joe Woolman, taking the stage.
Good morning, Mr. Chair, members of the committee. Nice to see everybody. I'm just here if you have any questions. I think the councilwoman, very succinctly stated the purpose behind the bill. I want to thank her office for their leadership and helping us work with the community, and we're looking forward to continue to working with them as we come back to you with a replacement PUD.
Okay, cool. Any questions for the applicant representative here? No? Okay. I think we probably have required findings of facts for this as well. do we have to do a finding of fact for the repeal of a PUD?
Yes. It's just two.
Yeah.
It's
Well,
two findings of fact.
Tell us.
One, that the repeal of the planned unit development is in the public interest, and that the approved final development plan of the planned unit development has been substantially completed, is no longer necessary in light of the property's underlying zoning, is no longer consistent with the city master plan, or has been abandoned by the property owner. So it has to meet one of those four criteria as well as the one previous.
Do we believe that we've met these?
We have.
Okay.
Yes.
I'll accept that as a finding of fact. All in favor of approving that, say aye.
Aye.
Aye. Opposed, say nay. Abstain? Great, we have findings of facts. We have no amendments on this bill. Councilwoman Porter, would you like to move it?
Yes, I'd like to move favorable approval of the bill.
Great, the bill has been moved favorably. All in favor of approving this bill, say aye.
Aye.
Aye. Opposed, say nay. Abstain? Great, this bill will be reported. Oh, Councilman Parker?
Yeah.
This bill will be reported as favorable to the full city council at its next meeting. Councilman Parker, do you have something to add?
Mr. Chair, yes, I appreciate it. I just wanted to thank my colleague and members of the community for bringing this forward. Growing up in South Baltimore, I remember very clearly when Mount Clair opened and the grocery store opened. It was a huge thing for a food desert and for families and the entire communities in South and Southwest Baltimore, and have kind of had a relationship with it over the years. We were just there the other day shopping after stopping by Holland's Market in my colleague's district. And so really appreciate the positive energy and you helping lead things forward there. So
Yeah, it's definitely a collaboration. Councilman Bullock and I, we talk on a number of occasions about that particular shopping center, so thank you.
Colleagues, I'd like to take a 10-minute recess before we go on to these other bills, these two other bills. We'll be back in 10 minutes. Okay, we're here. Okay, quick recess here. We have two last bills here. These are of a non-routine nature. We do not have bills present, but as I noted before, when somebody has spent money to advertise something, I don't want that money to have gone to waste. And in this case, it happens to be taxpayer dollars that the city council paid for advertising of these bills, and we're gonna hear them despite the sponsors not being here. I certainly have no intention of voting these bills today, and I don't know that there's going to be any outcry in this room for us to vote on these bills today. I do believe that we have some folks online. I will just ask, and I think Tony has probably noted in the chat, that if you wish to testify, please raise your hand, but be aware of which bill we're hearing at the time, so you're not raising your hand for a bill other than the one we are hearing and calling for testimony on at the time. So we will begin with, and to be clear, committee members, these hearings can be as brief as anybody wants them to be. I'll just also note that Councilwoman Porter had to leave, but we still do have a quorum here. We have council members Bullock, Parker, Gray, Blanchard, and I myself, Ryan Dorsey. So we will first call 250015 zoning conditional use crematorium. We do not have the sponsor of the bill here to present this bill. I will allow the planning department to, do you want to just summarize what this bill does? I can.
Sure, I can.
Yeah.
So crematoria are currently allowed by inclusion as part of the definitions for cemetery under section 1-303U and for funeral home under section 1-306U. This bill will define crematorium as a standalone use under a new section 1-304U. Is that sufficient? Or,
Yeah, in short, right now crematorium is an extension of the use of a funeral home, and so anywhere that a funeral home can go, a crematorium can also exist. And this bill is seeking to separate the two out as to two different use categories and make different standards, lesser standards as to where a crematorium can go, limiting it only to the C3 and C4 zoning districts as a permitted use, and to allow it as a conditional use in the open space districts. I definitely want a crematorium in the middle of my city park, don't you? Okay, so Planning Department, you've already spoken. You have a bill report on this, so what is your position on it?
Caitlin Audette with the Department of Planning. The Planning Commission heard this bill, reviewed the staff report, and recommended approval. Yeah, no findings of fact necessary.
Okay, great, thank you. Law?
Thank you, Mr. Chair. The Law Department approves for form and legal sufficiency.
Great, thank you. DOT?
Thank you, Mr. Chair. We have no recommendation on this bill.
BMCA?
Good morning, Mr. Chair. Justin Williams, BMZA. Apologize again for the lateness of the bill report. Ultimately, the BMZA has no objection to this legislation. The bill report did just point out 3 points for the bill or the committee's consideration as you consider the requirements in section 5-506 of the zoning code. First, regarding the emissions that are driving the legislation, the emissions concern driving the legislation. We understand and respect the community's concerns. The counterpoint or the concern would be that the zoning district boundaries are not an effective environmental buffer. The mercury vapor and particulate matter that are the primary concerns can travel hundreds to thousands of miles before they come back down. So the C2 versus C4 distinction might not meaningfully change who's breathing the air. And we would note that maybe the effective lever to pull it at the state level with MDE or MDH, who issue the permits for emission standards and have the scientific expertise to mandate better scrubber technology. The other point, two other points quickly. The second one was that just noting that the consistency with the code and other uses in C2 that are commercial, restaurants, bakeries, also have particulate emissions with no analogous restrictions. So we just flagged singling out one use could invite questions about consistency. And third, as a practical matter, the nonconformity issue. I know the Planning Commission noted in their report there were 18 of 46 funeral homes in the C2 zoning district. I don't think we knew or listed which ones have existing crematoria facilities, but any others operating that have a crematoria would be non-conforming upon enactment, and that means restrictions on expansion, difficulty obtaining financing, and ironically, potentially difficulty in even upgrading or installing new filtration equipment that would make it, would address the community concerns. So ultimately, we recognize this is a policy decision for the council and respect that, so wanted to provide that information for the committee. Thank you.
Thank you. So, I noticed at the end of the Planning Commission report, there is a table here that I think is listing every crematorium and funeral home in the city. It's just funeral homes, but every place that could potentially have a crematorium today, and therefore every place in Baltimore City that does have a crematorium today would be rendered non-conforming, and it's often cause for pause and concern when we make laws that make the wide swaths of things, let alone the entirety of things that exist in the city, non-conforming. In any case, finance?
This bill will have no fiscal impact on the city, so we don't we don't submit an opinion on it.
Great, thank you. Mayor's Office of Equity and Civil Rights.
Good morning, Mr. Chair, members of the committee. Zachary Wellman, Equity Policy Analyst for the Office of Equity and Civil Rights. While the Office of Equity and Civil Rights doesn't discern any inequity in the desire to protect residents from, pollutants and emissions as a result of crematorium services, specifically because, Baltimore does suffer from higher rates of asthma and other, breathing-related health conditions than the national and state averages, and this also disproportionately affects Black people, particularly within the city, at about a 6.5 times higher rate of hospital visits for that. In the case of this particular bill, however, we also identify, competing, equity considerations to be weighed here. Primarily, the one issue that you mentioned, that the entirety of all crematoriums in the city will be non-conforming, which significantly impacts one of the services disposable to residents within the city, especially because crematorium services, cremations, are a very important avenue for affordable funeral care. On average, the national median for a funeral with a burial and viewing is approximately almost 2 times the cost as the national median for a cremation service funeral and viewing. So the actual effect of essentially making all current crematoriums non-conforming and then, significantly limiting the ability for them to be existent within the city is going to have a disparate impact on those who are of lower income status. Additionally, with the fact that the Maryland Department of Health and Department of Environment already review on a case-by-case basis and issue permits to crematoriums to review, their health impacts on relevant residents, it kind of falls outside the realm of, something that zoning can address rather than, these, or should address rather than these individual crematoriums are already being assessed on their equitable impact on the health of residents. And if, they're deemed to not have that impact by the Maryland Department of Environment and the Department of Health, then that should not be much of a concern to, the health equity of residents. So ultimately, it could be, in theory, more inequitable to get rid of crematorium services and, make all the existing ones non-conforming, or not get rid of, but change the zoning to the point that they're in effect non-conforming and not possible, then the desire to protect some residents from an issue that may not really be existing currently. For that reason, we are without recommendation and just suggest that the committee weigh these, competing, priorities. Thank you.
Great, thank you. And I do see that we have been joined by Mr. Tyler Schnella. Good morning, from the Mayor's Office.
Good morning, Mr. Chair. Tyler Schnella, Mayor's Office of Government Relations. While we don't, have a position, the administration hasn't taken a position on the bill yet. What I will say is, just in reading the bill and in talking with, obviously, BMZA and reading the Planning Commission report, it is, and I do wish the councilman was here, not immediately clear why it's going to be moved to C3 and C4 only, and not in the industrial areas. And I say that because when I think about these, the idea that there's a chimney of some sort emitting whatever particulate matter, that there's a McDonald's in my neighborhood, and if you go there in the middle of the day and it's a little warm, you can tell when they just drop some new chicken nuggets or some new fries, or anybody that goes into Locust Point, where the Domino's Sugar Factory is, where they too have a stack that emits a very sugary smell, right? Or down near the H&S Bakery. How do we make the decision that this use should only be in C3 and C4? And if it is really about reducing the impact on neighboring communities, then I would think that you would put them in the industrially zoned areas and not in C3 or C4, which can still technically be in and around residential neighborhoods. And then I did ask yesterday for the team to show me a map of only C3 and C4 And it is few and far between in the city. And I'm trying to also figure out how much of C3 and C4 is actually able to be developed. And so are we effectively implementing a ban because it would not be possible for these folks to locate these businesses or crematories, however you refer to them, in a C3 and a C4? Those are questions that we have that I would like to, at the next opportunity, ask the sponsor about how we came to how he came to the decision that C3 and C4 are the areas that make the most sense for like what is kind of the rational basis for doing that.
I mean,
or unless you
don't forget open space, man.
Or open space, right?
Thank you. Well said. Thank you. Any questions for any of the agencies, the mayor's office with respect to this bill? Councilman Blanchard.
Thank you, Mr. Chair. This could be for planning. I'm not sure who this would be for. Is there any sense, I know the state has the license on crematoriums, but I think being someone who is consistently concerned about air quality, like I at least appreciate that concern. Can anyone from one of the agencies speak to, is there a evidence to show a concern of crematoriums from an air quality perspective?
I don't think I am qualified. Yeah, we don't have that information.
Councilman, I guess, Justin Williams, BMZA, in the bill report that was submitted late, I apologize again, that did a little bit of research, but not a lot extensively, but it seemed from like the EPA under the prior administration, so it might be more trustworthy. The EPA had made the point that the concern for crematoriums over any other kind of source of emissions is that there's the mercury for like people's dental fillings that are, I guess, potentially more toxic in certain situations. And that, I point out in the bill report that the mercury apparently is lighter weight, so it actually goes in the atmosphere and goes for hundreds or thousands of miles versus other types of particulate emissions, which maybe have more localized impacts. So that'd be like the argument for that. While there are some concerns about crematorium, it's not clear where and how it impacts the local vicinity, for better or for worse. And I guess I was looking for research too about if there's better scrubbers or filters that could ameliorate this. And this is where I would defer to the experts in this.
Okay, no, that's fine. All right, thank you, Mr. Chair.
Thank you. Any other committee questions on this bill? Do we have public testimony online? I want to ask you to raise your hands if you are online for Council Bill 015, a crematorium. If you are, please raise your hand and I will come to you after I call for any in-person testimony here. On crematorium, do we have public testimony here in person? Anybody here to testify? Yes, Ms. Salter? Seltzer. Do you, I see you have a injured leg, perhaps. Do you need to have can we bring the microphone to you instead of? Okay, do we have a timer prepared, Tony? We will give everybody testifying 2 minutes. Hit that button there to turn the microphone on. Okay. Staff will come and get those papers from you.
And if you could please go to your email, you have my testimony as well as documents.
All right, so we have.
Because I could not financially print.
All right, we have some printed documents here, and committee members are aware that there is something in their inboxes. Ms. Seltzer, you have 2
You
minutes.
can go to your email.
I'm not going to instruct the committee to open their email. They are here to hear your testimony at this moment. I won't ask them to read their email and listen to you at the same time. You have 2 minutes.
Okay, and then whomever else would like,
We will make sure that everybody who could possibly need them here will get them. You have 2 minutes. I would like
It's
to keep
the
this moving here.
35 chemicals from the Environmental Protection Agency regarding crematorium emissions. I'm first going to submit this, but I need it back because I only have 1 copy. This is to show that Enoch Pratt Free Library, Ricestown Road, Blanche, is in the C4 zoning.
Okay.
And also the proximity that C3 across the street have apartments in C3. So.
Okay. We have your documents. Please go ahead and tell us.
No, these are maps. This is to prove that Enoch Pratt Free Library, the Ricestown Road branch, is in C4, and across the street is our apartments, four-lay apartments. I also have another, which I could have done a ton of them, is the proximity of houses in C4 along 25th Street.
Thank you.
I mean, that should already kill this.
Okay, anything else to add?
So now I have a testimony.
Okay, you have a half a minute left.
No, I'm giving out papers.
I give everybody 2 minutes.
Will you tell us when to live? Will you tell us when to die? Tell me where the children pray. That's Cat Stevens. Whereas incinerators emit toxic chemicals into the air, the atmosphere, which according to the Environmental Protection Agency, crematoria emit at least 35 chemicals, including the top worst carcinogen polycyclic aromatic hydrocarbons that can conclusively cause cancer and other suffering to show slow deaths and illnesses. Whereas the Environmental Protection Agency confirms that following 35 polluting crematoria chemicals, carbon monoxide, lead, nitrogen oxides, particulate matter 10 primary, particulate matter 2.5 primary, sulfur dioxide, volatile organic compounds, acinophenylene, aldehyde, anthracene, arsenic, benzoanthracene, benzoprene A, benzofluorethene B, benzo-GHI, perthene, lithene, benzo-K, fluorethene, beryllium, cadmium, chromium, chrysene, cobalt, dibenz, AH, anthracene, fluoranthacene, fluorine, formaldehyde, hydrogen chloride, hydrogen fluoride, endo 123-3D, prene, mercury, naphthalene, nickel, phenolphthalein, purine, cellium. I was here on October 21st, 2024, and it's beyond anything that you would dare try to. We already have 46 crematoriums, according to the Department of Planning. Stop. The only way you can save this is to amend it to a natural composting only, because that's the only thing that won't hurt our environment, won't have any waste.
Thank you, Ms. Seltzer. Appreciate your testimony today. Thank you.
So I need the email to be able to email all of the testimony that needs to be placed on this. And I need those papers back, please, for the Enoch Pratt Free Library. but please pass it around
Okay.
so that you can see.
Okay, we'll make sure that you get your maps back. Thank you. Do we have anybody online to testify on this bill, Tony? Any? Micah Hayden, you will have 2 minutes. You should be able to unmute yourself. Let's see, yeah, okay, we've got you unmuted. Micah, you have 2 minutes when you're ready. Can you hear me? Can we hear you?
Yeah. Can you hear me? Can you hear me?
Barely audibly.
Is this better?
That is.
Okay. I just have one question for the city council. Is there going to be any wage increases, not wage increases, but the capital increases to the people who are cremating once the effect goes through? Because you're limiting the supply. Will there be a cap on the amount of people the amount of money that will be spent? That's my only question. And I want the city council to think about the cremation process. And if they limit the cremation process and everybody's ineligible, what happens to the rest of the community at that point? That's all. Thank you.
Thank you, Mr. Hayden. I don't think that we will actually have a response to the question, but it is taken as reasonable rhetoric, and that I think the point here is, I heard it as if we limit the availability of cremation services, that it will drive the cost up for those who use it, a basic supply and demand concern. It is noted. Thank you. That concludes those. Oh, we do have Cassandra Nesmith. We will unmute you. Okay, you've unmuted. You will have 2 minutes.
Good morning, Council. My name is Cassandra Nesmith. Hopefully you guys can hear me.
If you could speak up at all, it would be great.
Wonderful. I am personally in opposition of the cremation, particularly because of the pollutants that are released, such as mercury and other type of particle matters. I strongly believe that it has a high degree of negative effects on people's health, such as you mentioned, asthma and other respiratory issues. So in conclusion, I'm definitely against it. I think that these pollutants can definitely impact negatively the lives of others in the area, especially because it is a heavily populated area. I think that maybe a different alternative could be used. If it is a necessity to implement these crematories in the areas, including including measures to make sure that the residents are not negatively affected in their health, or increasing the type of filtration that are included in the crematories to reduce the negative impact to the residences, again, because it is a highly populated area. So if it is possible to maybe put them in the more industrial areas of Baltimore, that would be extremely helpful to make sure that they are away from residents who are already suffering respiratory issues.
Thank you for your testimony. Okay, there being no further public testimony on this bill, that will conclude our hearing on it. We now move on to Council Bill 250016, Zoning Code, Minor Variances, Modifications. The sponsor for this bill is also not here with us today. Again, it's been advertised at expense to the taxpayers, and in particular, it has come from the City Council's budget that it is advertised. And we will not waste taxpayer dollars foregoing the opportunity to hear this bill as we've paid for it. I'll take the liberty of presenting this bill myself today. The bill is brief. The substance of it is on page 2. And it proposes several changes to the definition of minor variances. Variances are a standard that is required to be met, that there is something particular or unique about the specific property, and that they're fairly stringent in that they're not supposed to be granted for the purpose of just accommodating an owner or user's desire, but to say that essentially anybody would have difficulty meeting the standards for the use at this particular property because there's something unique characteristically about the property. And that is a matter of fact finding that has to be done in order to grant a variance. And we divide them in the zoning code into 2 different categories, minor and major. And both require public notice and posting, but it's a matter of degree. And in particular with minor variances, there is a standard that says that they can be, though public notice is required that it will be considered, a minor variance can be granted by the zoning administrator without there needing to be any public hearing, so long as nobody writes their objection to him. If a person sees the public notice and says, well, I don't like that, then they write a letter to the zoning administrator saying that they oppose it. Then the zoning administrator says, I am not authorized to approve this minor variance. It must go to the zoning board or the city council, as the case may be, to be considered in a public hearing. And those minor variances, and that's not the case with a major variance. A major variance always requires a public hearing. And so the distinction between minor variances and major is one of degree. For example, the current standard says a minor variance comprises the following specified variances: a reduction in lot width by no more than 10% of the applicable minimum lot width requirements. And this would propose to change that from 10% to 15%. And it says a reduction in required yards and setbacks by no more than 10% be changed to 15%, or 2 feet be changed to 5 feet, whichever is less. I think that one in particular, to me, is evocative of the minimal impact that this bill could possibly have. A reduction in required rear yards and setbacks by no more than 10% being changed to 15, or 2 feet being changed to 5 feet, whichever is less. And that's interesting to me because when this bill was introduced, we had a setback requirement that was common for side yards that was 10 feet. And the standard would say that a minor variance could be approved if somebody wanted to go down to 9 feet under that 10% rule. And to change that from 10% to 15% would mean that that person could go down to 8.5 feet as opposed to 9 feet. And It was my understanding that the impetus for this bill was that a person in the sponsor's district had been denied a variance wanting to go down to 7 feet. And so this wouldn't even fix the problem, because it also says here the lesser of 15% or 5 feet. And so it wouldn't allow them to go from 10 feet to 5 feet. It would only allow them to go to from 10 feet to 8.5 feet. What we've done in the interim, by the passage of another ordinance, is just change that standard from 10 feet to 5 feet. So now anybody wanting to go down to as little as 5 feet doesn't have to seek a variance in the first place. And so I don't really understand why this bill would be necessary at this point. Further, the bill in section 5302B6 says a variance to bulk or yard regulations if the variance application involves a single family dwelling within a residential district. This to me is a dramatic departure from everything that we think of as cause for a minor variance. Everything before that, 5302B1 sections or subsections 1, 2, 3, 4, and 5 are pertaining to degree of intensity of usage, things expressed through generally percentages or hard numbers. This bill proposes that in addition to all these things that are measurement-based, that we add to it something that is entirely, essentially use-based, meaning that any variance whatsoever to any degree whatsoever can be approved as a minor variance so long as that is for a single family property, which means that if I do my public advertising, my notice, I put my sign up on my front lawn and nobody reads it particularly carefully, then I could be putting up notice that I want to have my house be extended to be 50 feet taller than every other house in the neighborhood and cover 100% of my lot area and have no setbacks on the front, rear, side yards, and that I could have zero impervious surface, zero pervious surface on the lot, and I can defy every single bulk and yard standard that there is to any degree whatsoever. And so long as nobody writes a letter to the zoning administrator saying, I oppose this, the zoning administrator can approve it without any public hearing whatsoever. And so good for me if I can get that done. But woe for my neighbor across the street who says, Dorsey has a house that's 50 feet taller than mine and covers 100% of his lot area, and I like it, and I want to do it. And so neighbor across the street puts up the advertisement for the same thing, and the neighbors are now going, oh, he's doing the same thing that Dorsey did across the street. It's hideous. I hate what Dorsey did. I don't want this in my neighborhood. I'm going to oppose this. And they write a letter to the zoning administrator. And the zoning administrator says, well, somebody opposes this. I can't approve this, just like I did that last one. We're going to have to call for the BMZA to have a public hearing on this. And then the BMZA hears it, and they say, well, your property is the same as Dorsey's across the street. There's nothing unique about your property. You don't qualify for a variance in the first place of any degree. Denied. And then the neighbor says, well, how did you approve it for Dorsey across the street? Well, just nobody said that they opposed it, so we just said, whatever, it's cool. We just approved it. And that is just not at all good public administration, in my mind. And that's what this bill offers. That's what I have to say about it in presenting it. Law Department.
Thank you, Mr. Chair. The Law Department approves for form and legal sufficiency.
Thank you. BMZA?
Thank you, Mr. Chair. If you indulge me, I was helping to work on this legislation the last term as deputy mayor. I know my predecessor put a bill report saying no objections. To give some more context or background for the council. So there's already a minor variance regime in the code since Transform Baltimore. We haven't actually utilized it as a city since it's been in the code. My intention and hope, notwithstanding the chair's concerns, was to start moving forward with this process in some shape or fashion, some form or fashion. The general rationale being that, with the consent docket or even docket cases at the BMZ that are heard in a public hearing, many, or I don't have a specific number, but the high proportion are approved without any kind of muss or fuss. And if there is near universal approval, then the BMZA is not always serving as a filtering function. It's just a toll that's mucking up the process, making it harder to build in the city. And have obviously the hearing process for minor things that don't really require, in my opinion, the full neighborhood coming out, or even just one neighbor coming out, still means that a homeowner, property owner doing something minor has to bring architects, engineers, consultants to the city during the day, have a hearing. And so the thinking, I think, for the existing legislation in place, the existing code was to have an option to say, hey, if it's a minor request, it shouldn't need a hearing if it meets the standards. Now, I think the concern you raised is fair, is that if there's a zoning administrator delegation that is, and he makes a different determination in how he sees things versus the BMZA, there is an option, there is the risk of, I guess, being inconsistent. My vision for how to implement this was going to be, and I was talking to the planning director about this the other day, was that the zoning administrator could delegate the authority to, like, the BMZA director to start doing this process. So that's the kind of general overview. You mentioned the point, which I think is also a fair one, that with legislation you helped to pass last month or a few months ago to reduce the setbacks, there are already fewer cases coming to the board. So that sort of does make the point you're addressing. Still the point remains is that, in my opinion, as a former land use lawyer who would be hurt by this sort of legislation to make it less of a requirement to have a lawyer, is that there should be a easier path for certain things. So obviously we just disagree on the public policy matter. The reason for putting the specific provision, it's at letter or number 6, which is for any single family dwelling in a residential district. I actually drafted that to copy Baltimore County's version of this, which is any owner occupied dwelling can get an administrative variance. They've done this for a couple decades at least, to have a path that says basically what you said. You post the property, if no one objects, then the ALJ in Baltimore County can approve the variance, and they analyze it under the same standards. So that was sort of the inspiration. There was concerns about equity and fairness there for owner occupied, but my counter argument is that we have, the tax code allows for, well, not tax code, our tax regime has processes for owner occupied dwellings versus non-owner occupied dwellings. I know you and I have discussed the concerns about that, but there are already examples and precedent of how we treat owner-occupied dwellings differently, and there's argument that we want to promote investment from owner-occupants to stay in the city and expand their property and make it easier. So that's sort of the rationale thinking. Hey, if you want to do a roof deck, expand your kitchen, we want to make it as easy as possible to do. So that was the rationale behind it. So that's the inspiration. I also talked to Councilman Blanchard about some things like other uses that could be allowed, like childcare still requires a BMZA hearing in the C1 district. And if we recognize childcare needs to be more affordable, these little friction points of having a hearing and costing $5,000, $10,000 to do the process doesn't make it easier. And so that's kind of the general rationale of having things to be a little bit easier to do, as many of the laws you've passed in the past few years have driven us towards. Thank you, Mr. Chair.
Thank you. I love the idea of making reasonable things easier. I mean, I think we've taken considerable efforts to do that. And I love the idea of, if we want to change it so that childcare doesn't require a hearing in certain districts, we should change the requirement of those districts to not require a hearing. But I do, we need a lot of housing in this city. We need a lot of housing in this state, and it doesn't seem to be sensible to me to create special dispensation for single-family dwellings that we wouldn't make for multifamily dwellings, considering single-family dwelling only provides housing for one household, and a multifamily dwelling provides housing for multiple households, and I think that that's a greater public good. And that if we're making special dispensation, then it should, at the very minimum, be set aside for the greatest public good. Let's see, what other bill reports do we have here? Planning Department?
Caitlin Audette with the Department of Planning. Just a note, this was heard by Planning Commission almost a year ago, so February 28th. So some things have changed since that time, so just kind of want to put that out there. The Planning Commission reviewed the proposal and recommended an amendment, which was to remove the word "and" to make it so that you don't have to have a single-family dwelling, and recommended approval. They also deliberated and asked that the council consider provisions for notice for minor variances. So right now, notice is provided to immediate neighbors. There might need to be additional notice for community organizations. So again, that was a conversation they had last year when this might have been larger requests, when now it's a much smaller setbacks and those kinds of things, but just a request that they had. So the Planning Commission recommended approval with that minor amendment.
Thank you. I'll also note, I feel like changing notice requirements for minor variances was something that came up the last time we did a general code update where we were making a bunch of changes to the zoning code. We may have made some change to it then. Joan Floyd is here and I think made some notes about where we would have run afoul of state law. Maybe it wasn't particular to this one, but I know that we had to double check whether we were seeking to change locally things pertaining to notice that we are obligated to do because of other superseding laws. In any case, that seems to me something that we could include easily in a general zoning code update and discuss in that context. Finance Department?
We have no we don't have an opinion on this legislation.
DOT?
Thank you, Mr. Chair. We have no recommendation.
Great. That's everybody we have on the... This wasn't actually referred to DHCD, was it? It was. You're not on the bill and you're not on my sheet. DHCD, you have a report?
Yeah, Jason Wright representing DHCD, and it was quite a while ago. We sent our bill report in about a year ago, and as planning gestured to, that was before several bits of impactful legislation were enacted. The one that's going to affect DHCD the most would be that the zoning administrator is no longer housed within our agency. And so I would say that we stand behind our favorable bill report, but at this point, it would not be impactful on DHCD. So I'm not sure we would be referred it if it were issued today.
Thank you. Any comments or questions? I've done plenty of commenting myself. On the committee, Councilman Blanchard.
Thank you, Mr. Chair. I think Councilman Gray's 250064 addressed the bulk and yard sort of standards already. But I think if the bill sponsor, I would be willing to consider a bill that had maybe slightly more flexibility for single family in a residential zone or something, if there were actual caps on what that flexibility would be. The idea that there would be literally none if no one objects to it is sort of a fascinating social experiment. But not to be crude, but I mean, just like if it was like, maybe it's 15% or 20% or something in that specific situation, a different type of zoning variance, I personally would be willing to consider something like that, but obviously that's not the bill that's for us. So, thank you, Mr. Chair.
Thank you. Justin?
May I respond? Thank you, Mr. Chair. Point, I admit it getting lost, but while there could be a minor variance in this, as proposed and drafted and as I conceived it, you would be able to have your case reviewed by zoning administrator or whoever his designee is if it were a 50-foot tall extension, but there would still be the application of the variance standards. And so whoever is delegated with responsibility, myself or whoever, would still have to review it and see if it can qualify for a variance, meeting the standards. So it wouldn't just be like a rubber stamp, it would be going through the process and without the hearing. So basically, it'd be the same analysis that happens by the board, and the staff prepares reports, and as the board director, I give guidance to the board members before the hearing. It's basically just doing that guidance, but without the board having the public hearing is basically how I conceived it. So there would still be that check of properties.
Thank you.
Yeah, I do have a follow-up question to that, Mr. Chair. Thank you. So for Mr. Williams, so this doesn't actually directly create a sort of the consent docket situation. It just means that there wouldn't be a the public hearing wouldn't be required in the case of, so theoretically I guess this would be either the zoning administrator or the BMZA would be able to consider, do the findings of facts and everything and make the consideration there. Okay. Thank you, Mr. Chair.
I'll note the difference between having a single person review an application here in Baltimore City, being the zoning administrator, versus having a single person review an application in any other jurisdiction in Maryland. Is that in any other jurisdiction, that single person is an administrative hearing officer or an administrative law judge who writes findings of facts and essentially renders a legal determination on in writing for each case, demonstrating that they have reviewed the facts and applied the legal standards. And that doesn't happen necessarily. That doesn't happen when the zoning administrator reviews anything else that they're allowed to approve by right here in the city. Nor do I believe that the zoning administrator's office is staffed by legally equipped people to review the legal standards and do legal findings of facts. I have also expressed a real interest in Baltimore moving to the kind of administrative hearing officer system that other jurisdictions have, because I do believe that in many ways that would create a much more streamlined opportunity rather than waiting for extended periods to get public hearings on things, based on the zoning board meeting twice a month throughout the year, and the docket capacity that they can handle versus a person whose full-time job it is just to hold hearings, as is the case in our surrounding jurisdictions. However, we are not empowered to make this change entirely on our own, because the reason we are different from all the rest of our jurisdictions is that our system and our structure of government preceded the rest of the state's zoning laws. And so when the zoning law was being written for the rest of the state, Baltimore City was carved out and just said, okay, that's your system, we'll just let that be your system. And then it was enshrined in state law. And so we have various aspects of our system that we would need state legislation to change. That's my comment on that. Councilman Gray.
I think you may have answered my question that I was going to pose to Justin, which is structurally, what changes would have to be necessary with staffing and procedure to make this process efficient as the sponsor suggested. because it explicitly says that anything that goes in front of the zoning administrator automatically goes to the BMZA. And so when you take that away from the BMZA, what structural changes would need to happen for like staffing and procedure wise for this bill to be as efficient as it's being labeled?
Right, so I mean, technically, the law and authority already exists in the code now. It hasn't been implemented, I think, for the reasons that the chair had pointed to, is that the zoning administrator has felt that he wasn't equipped with the staff or capacity to make the findings, and so he sort of has pushed everything to the board already that would qualify today as a minor variance. My intention in hearing the chair's concerns, I was thinking maybe the committee and the council could change it to delegate it to a lawyer or the BMZA director or something like that to give you some more comfort going forward, because the law currently exists and we have the authority already to do this. I do think, to make it happen effectively, I was trying to do it. I don't have a deputy anymore. She resigned. So my vision was if I get a deputy, I'll have more capacity. And the concern that the chair raised about if the person who puts a sign on their property and the neighbors don't see it, which is reasonable, I was thinking to myself how to best implement better notice systems for like neighborhood associations. Can they sign up to be on our mailing list? Or can we be even more targeted to have like, when it's in a certain neighborhood, then it sends the notice? Because my fear is people get email overload and don't look at it, because if they get a blast email every time there's a hearing, most of the time it doesn't pertain to the neighborhood. But if you had a more targeted selection that says, hey, once there's a project in 10 Hills, then we send the 10 Hills groups that signed up for notice to be aware of it. And then that would help cover the concern about people missing or not being aware of a sign.
Yeah, because you also run the risk of neighborhoods. I know there are some in my district, along with others, specifically on the west side, who may not even have a community association. Yeah. And so there's a big question about equity when someone could just put a sign indiscriminately anywhere on their property. And, shout out to 10 Hills and Hunting Ridge and, a bunch of other Howard Park, they would be on it. They would see it, they would report it, I would hear about it, but then there are other communities where they just wouldn't. And so this gives developers or someone trying to just do whatever they would please a really easy way to just usurp authority and do what they would please. So thank you for answering the question.
My counterpoint is like I hear of the deputy mayor. I'm sure you hear it too. Is like when there is a hearing, it goes to the planning commission at the council. They're like, I didn't know about this, and people. There's many hearings, and we can't knock everybody's door. We post in the Daily Record for these kind of hearings, but who reads the Daily Record to check for these sorts of things? I think there's lots of ways we should think about having better notice. I'm not a big Instagram guy, but I know it's where the kids are. So like, should we start posting the dockets on Instagram? Like, and just things like that.
They're on TikTok. Then
I don't even know that.
Us old people on Instagram.
I'm still on MySpace, so thank you.
Okay, Councilman Blanchard had to go, but we are gonna wrap up here the committee questions and such. We do have some people online to testify. We're gonna ask them to raise their hands, but first we will go to our in-person testimony. Do we have in-person testimony? Joan? Floyd? Ms. Floyd? Yes, please. We just have one person here to testify in person, after which we will go straight to the online testimony. Again, we are not intending to vote this bill today, certainly. And we're going to ask everybody to keep it brief. We're going to limit everybody to 2 minutes. Thank you.
Mr. Chair, fun fact, the City Council can actually already have administrative hearing officers handle many of its hearings. You just all, for some reason, don't take them up on that. That's in state law.
On what?
This bill is being heard at a particularly bad time for owners and residents of single-family dwellings, which, as you know, include all row houses, semi-detached houses, and detached houses. Right now, there are bills under consideration in Annapolis that may force significant changes in our bulk regulations, including reductions in setbacks and minimum lot areas. We don't know what the outcome of these bills will be, but we should know fairly soon. Locally, there is pending Bill 250066, which, if it passes, will engender new kinds of variance requests as people inevitably pursue more units. There is also the state ADU or accessory dwelling unit mandate, which requires legislation to implement it locally. That will include bulk regulations for this new housing type. These pending matters make it impossible at this time to assess and understand the effects of today's bill 250016. So I urge the committee to wait for the completion of these other processes before requiring final testimony on this bill, and it may even feel like it's not necessary. Who knows after that point? What I can say at this time today is this: minor variances do not get a BMZA hearing unless a formal objection is filed. If you classify all variances as minor that involve single-family dwellings, you are requiring neighbors to file formal objections just to have a hearing on something that could be very high impact. This does not seem reasonable or consistent with the concept of having minor and major variances. Also, there is no public listing if you make this switch. Right now, the BMZA is required to publish its agenda, and that public listing is very important for people. And moreover, the term involves a single-family dwelling seems ambiguous and open to interpretation, especially in light of the pending bills I just mentioned. Thank you.
Thank you. Appreciate it. Ms. Pryor, you'll have 2 minutes.
I would like to echo the concerns of Chair Dorsey, also the concerns that were raised in previous testimony in opposition. I just wanted to highlight how much strain having to file a formal opposition or a formal letter towards the BMCA would be on mostly volunteer neighbors that kind of are the overseers of these homes. And really, the main issue that I have with this bill is the single family, inclusion of single family as a minor, variance. Obviously, we really appreciate the ability for that changes to single family homes to go forward as an ordinance at the city council. We have a great communication style with our councilman who lets us know anytime an ordinance would need to be filed to change a single family home to a multifamily. We are 70% multifamily units in our neighborhood of Reservoir Hill, 30% single families. We do believe a diversity of homes is needed for large families and families who live in with multiple different family units. Some people have their grandparents, their parents living in one home, and Reservoir Hill is one of the few affordable places to do so. We want to maintain that without all of the additional strain that it would require through this bill. And appreciate the additional commentary that was made to kind of flag all the issues that it would bring for the community, for the city. We just feel as if certainly we should hear about 6.6 before this moves forward. It seems like this is just a cacophony of information around how single families will be treated in the city. And we just want to not be surprised by all these different types of bills that will just cause confusion and lack of order. So thank you for hearing our testimony, and that's all. I don't need to add and, echo the things that were said previously.
Thank you. We'll go to Ms. Carolyn Carey. And I encourage folks to, if you've already heard others say what you need to say, just, let us know that you've already heard others say what you need to say. We don't need to hear repetition here. We just want to make sure that we get the broad range of viewpoints on record. Ms. Carey, you have 2 minutes.
Thank you so much, Chair Dorsey. While framed as a streamlining measure, this bill would weaken longstanding zoning safeguards, reduce meaningful public oversight, and create unnecessary certainty and neighborhoods across Baltimore, I urge the council to reject this bill or substantially amend it to preserve transparency, community input, and the core protections of the zoning code. There is no demonstrated need for this change. The city has offered no data showing that the current 10% minor variance threshold is causing systemic delays. In fact, the BMZA already reviews variances cases efficiently. Adjustments to administrative overflow, not a weakening or public processes, but be a better solution to any bottlenecks. Even the BMCA notes that the bill will not work as intended. The board has stated that the zoning administrator currently forwards all variances to the BMCA. Unless that practice changes through clear policy and staffing adjustments, the bill will have no meaningful effect other than creating confusion and who is responsible for what. For these reasons, I respectfully urge the City Council to vote against Bill 25-00616. At a minimum, significant amendments are needed to ensure robust notice, guarantee community association input, and clearly implementation guidance, none of which appear in the current legislation. Thank you so much.
Thank you. Cassandra Neesmith.
Good afternoon, well, good morning again. I just want to add my 2 cents into this. I kind of want to piggyback on what others have also echoed, but I also want to highlight the fact that we definitely need more affordable housing. So will building in Baltimore City allow for more housing options for residents? Yes. However, for the, housing affordability would also be extremely helpful. There are many in the city who cannot afford it. I think we all know this. Additionally, I do have questions about what minor definitions are. And the reason why I ask that is simply because what if a single family abode decides to do a minor, quote unquote, reconstruction on their home and it then becomes a multifamily home? That is something that a lot of residents would need to have input on, and burdening them with the responsibility of going through additional steps of reporting where they may not even be aware of how to do that would add a burden onto residences. Additionally, reducing parking, I noticed in the documentation, I think that would be crazy in a city that is historically tight on parking, especially for residences. I don't see a way forward on how to, remedy that if we're decreasing or have the ability for it to be decreased parking wise, including alleys. A lot of residents park in the alleys to decrease the need of parking on the street, which can be very full. This can actually put a more strain on residences, more stress on residences where we're already stressed with, lack of housing or affordability in the city. And unless the city is thinking of increasing the fees or parking lots, which includes fees for residents, which would also add an economic strain, I don't think this would be feasible.
Thank you.
That's the end of my statement.
Thank you for your testimony. Kathleen Katarba. Kathleen Katarba, your hand was up. It is no longer up. You've not unmuted yourself. We will move on. Take it that you decided you don't need to testify. Deb O'Neill.
What? I'm sorry.
I'm sorry, Deb. We're going to come back to you in a second here.
Of course.
Ms. Katarba has jumped on here.
Thank you, Chairman Dorsey. Please add us to the record in opposition of the legislation. We urge the City Council to honor the public in the process, and we thank you for this opportunity. We would like to see provisions to continue for public notice and the hearing process for the major variances. And we think it would be a very good idea to have some clearly stated guidelines for what is major and what is minor, so that those projects that truly are very, very minor don't take up everyone's time through a hearing process. Chairman Dorsey, you stated the problematic aspects of the bill, and we really appreciate that. And we believe that there is a need for greater clarity and transparency in this. And it's important, above all other considerations, to stay connected to the people and the neighborhoods. And we appreciate the time. Thank you.
Thank you. Deb O'Neill.
Yeah, I'm here. Thank you so much. I'm here to speak in opposition to 25-0016. For me, this is just another bill that seeks to make things easier for developers at the expense of the interests of communities and existing single-family homeowners. It goes hand in glove with CCB 25-0064, 65, and 66, and reducing the rights of residents and neighborhoods to know how their communities are being reshaped by speculators, by denying them the level of knowledge and processes they now have to protect themselves from outside interests that have no cares for the issues that matter to the existing residents. This is being framed as a bill that will make it easier, quicker, and less expensive for homeowners/residents to make changes to their residences. In reality, it's about making it easier for developers to develop investment properties at the expense of the rights of communities and residents to be informed about what developers are doing in their neighborhoods and object to changes that will have a negative effect on the character, stability, and property values of our neighborhoods. To quote your own planning commissioner in his testimony, there is concern that expanding minor variances could weaken the zoning protections that homeowners have come to expect. By allowing more variances to be approved administratively, residents may have more difficulty providing input on changes that could affect neighborhood character, stability, and property values. Ensuring transparency and maintaining public trust in the zoning processes will be important considerations as these changes are implemented. Those issues are overriding concern right now in light of how 25-0066 has been handled. I'm urging people to vote against this, but I also want to just state that I was quite concerned to hear comments made about zoning changes being an social experiment. We've had experience.
Thank you, Ms. O'Neill.
With that, and I encourage you to never speak like that again.
Thank you. Michael P. Scott.
Can you hear me?
Yes.
I oppose 25-0016, Chairman and members of the committee. Proposal does not simply reclassify variances, it restructures public oversight in Baltimore's land use process by automatically designating all single-family variances as minor. The bill removes default hearings and shifts the burden on the residents to file formal objections just to preserve the review. That reverses the purpose of having both minor and major classifications. Single-family variances can have significant neighborhood consequences affecting density, parking light, infrastructure strain, property values, and long-term stability. Eliminating automatic review does not reduce impact, it reduces visibility. The structural change is being presented as technical. It is not. It narrows transparency. At the same time, we continue to conflate affordable housing goals with broad by-right expansion for developers. They are not the same. There is no rigorous Baltimore-specific evidence demonstrating that entitlement expansion in the city with documented enforcement shortfalls, inspection backlogs, budget constraints, and uneven neighborhood exposure will produce equitable affordability outcomes. Affordable housing requires enforceable requirements, infrastructure readiness, and ownership protections. By right acceleration without these safeguards is not reform, it is risk transfer. Meaningful public review is not an obstacle, it is a safeguard. I urge you to reject this bill to preserve accountability, land use governance. Michael Scott, Ashburton Area Association board member. And I will echo the last comment that, we've never seen, in this country, powerful councilmen joking about social experiments go wrong in the Black community. That's never been a problem. So yeah, I urge you to reconsider how you do that in a public forum as well. Thank you.
Thank you, Michael. Micah Hayden.
Hello, council members. I am concerned with Bill 25-0016 because I live in Ashburton. Ashburton is a community that is historically. However, I live on the outskirt of Ashburton, and that is right on the edge of Callaway Garrison. I live on Callaway, and since you all are discussing the possibility of having an amendment where just attorney or a legal authority has one person, a legal authority, not a legal counsel, has the ability to review. I'm concerned with how they view Callaway or any other cross street that is on the edge of a historic community or on the outside of Baltimore city historic areas. The reason I say this is because when you have one legal authority reviewing, you don't have the intake or the input from the whole entire community. And I believe that's being lost in the review. I do not want that lost in review, so I ask you all to oppose this bill. Please, in efforts, be kind to your neighbors. Do not propose a social experiment. I echo that again. This is the second time we've heard that from the council members about a social experiment. So please do not have social experiments in our city of Baltimore. Thank you. Have a good day.
Thank you. And last person for testimony, Nicole Gatewood.
Thank you, Chair Dorsey and the committee. My name is Nicole C. Gatewood, Esquire. I'm the president of Philadelphia Heights Neighborhood Association. We have presented formal testimony in opposition to Bill 25-0016, but I'd like to use my 2 moments to echo a couple points. One is that all single-family zoning matters are not minor and inconsequential. To allow the process to be undertaken in a way that systemically removes neighbors' voices from the table is not only dangerous, but it removes the entire nonpartisan process that we rely on. As Mr. Hayden spoke to, even allowing council to be involved, all council do not have the same perspective. It removes checks and balances from the process, which is extremely critical when we're talking about zoning. Zoning involves generational wealth. It is a tool used in all communities, not only Black and brown ones, for wealth generation. But in a neighborhood or a city like Baltimore that is predominantly Black and brown, that has substantial consequences. It is incumbent upon not only this council, but this committee to think about what is most important for neighborhoods, all neighborhoods, not covenant neighborhoods, not neighborhoods in historical districts, but all of Baltimore City. And that requires not having a one-size-fits-all change to this variance. I implore you to take into account the testimony you've heard today, both written as well as oral, to go back to the drawing board and think about how you can better accommodate those neighbors who do have minor needs for variances, because we do not want them to be disenfranchised and not able to make changes to their homes. They deem one size fits all in a way that removes the voice.
Thank you, Ms. Gatewood.
The needs of all of us. Thank you.
Thank you. This concludes our hearing on this bill.